dear friends. It is our pleasure, our honor to welcome you to this 26th Global Digital Encounter dedicated to the new system of patents and jurisdiction on patents in Europe and in particular in the EU environment. The adoption of two regulations permitting to have what we call the unitary patent is permitting to grant patents to as a single instrument in European Union states, at least for the time being, in those adhering to the system. In addition, an international instrument called Unitary Patent Court has been created in order to permit the proper enforcement of the said patents at an EU level. As such, at an EU level or at an EU level of the member states of the EU that are party to it. As such, this system brings new challenges, fantastic opportunities, and also, as criticized by some academics and some professionals, some drawbacks, and also some question marks. This is a new system, a system that starts after more than 60 years of negotiations, so very, very long time. What will be its future? How will it develop? This is why we have invited the most prestigious speakers today to be with us and to discuss from a European point of view. We have two European speakers. From a non-EU point of view, we have one US speaker. The approaches that can be taken in front of this new system that is together extremely attractive in appearance, sounds frightening with some drawbacks. What should it be and what should it become? So for this encounter, we warmly thank all our sponsors of these pro bono activities, all our participants who are connected from all over the world, and as co-director of this Global Digital Encounter, jointly with the coordinator, Javier Fernandez-Laschetti, we have asked the other co-director, Professor Manuel de Santos, to be the moderator of the speakers due to his immense depth of experience in the field of patents, thanks to his past as former vice president of the European Patent Office. And we will leave him the floor to conduct the debates in this very, very occasion. So, my dear participants, we will have a debate between all our speakers and our moderator. And we also count on your input in the chat to raise questions, so that these questions be handled and be replied to by our distinguished speakers and moderator. I would now wish to leave the floor to Professor Javier Fernandez-Laschetti, our coordinator, who wants also to greet all of you to this very special event. We are among the first international entities to create a global digital encounter on this very topic. And we are very proud that we are well before the 1st of June, the entry into force of the new system, to discuss already about these questions and to enlighten our distinguished audience. Javier, the floor is yours.
Thank you, Laurent. And as usual, just a few words, because I think it's much more interesting to hear the speakers and the moderator. Yes, it has been a long journey, from 73 to now, and one could imagine that we will never face this situation because we Europeans have taken a lot of time discussing this issue, but it seems that it will come into force. So a new system, a new era will come, probably will be more in line with the US system. Who knows? We have a specialist on US patent law to explain to us. So I'm very, very happy to be here. Just to tell you that we are welcome as usual. You know that you belong to a community, and we hope that you will enjoy this meeting. And thank you very much, and Manolo, the floor is yours.
Thanks very much, Javier. This time, good afternoon, good morning, and good evening, everybody. This time I asked to be the moderator, and could not be otherwise, because my feeling is that I was born already dreaming with 1st of June 2023, and have been so many years behind. So for this occasion, we have to find three very good experts. And it is my great pleasure to introduce you first to Professor Craig Nard. Professor Nard is already a member of our family of the Encounters, and is the Gallen Rusch Professor of Law and Director of the Spangenberg Center for Law, Technology, the Arts at the Case Western Reserve University School of Law in Ohio, in the United States. Then Professor Thomas Milley, Professor of Commercial Law at the Faculty of Law of the University of Turku, Finland, and also Director of the IPR University Center. And then Dr. Matthias Lamping, Senior Research Fellow at the Max Planck Institute for Innovation and Competition. Matthias is German, but I like to say that he's half German and half Spanish. So welcome you three. You know, Javier Fernandez Laschetti said that we are waiting since 1973. In fact, Javier, the first draft of the Community Patent Convention dates back to 1962. It's more than 60 years. And since then, what I call a history of perpetual frustration has led to the institutions of the European communities and their member states from failure to failure. The first failure was 1962. But then at the beginning of the 70s, I would like to recall that the main document split it into two, and that's the reason why the European Patent Convention arrived, the European Patent Organization arrived, and the European Patent Office arrived in 1973. In 1973, two conventions had to be signed at the same time, but only the first one was ready, not the second. So that's the reason why the 1973 convention flied and the European Patent Organization came into life. While in 1975, we had the second convention, the Convention of the European Community Patent, and it didn't fly. And it didn't fly in 75, and it didn't fly in 1989. And it looked like it was going to fly in the year 2000, when the European community got a legal basis and shifted from an international convention to a regulation. And it looked like in 2003 there was already an agreement at the Council for the first time ever in the history of the European community. This agreement didn't fly again. I recall Prodi saying in public that the failure of the community patent had been the most important failure in their term as a president of the European Commission, but it didn't fly in 2005 neither. It didn't fly in 2009 when the Court of Justice stopped it in a very famous judgment, and finally it looked like it flied in 2012. But then split it into two pieces again, two enhanced cooperation procedures on the one side, and then on the other side, an international agreement open to the signature of the member states of the European Union. This was the package, It took 10 years to arrive to 1st of June 2023. Now it is a great event that the new system will enter into force in just 3 months. And it would enter into force for 17 of the 27 member states. So in this global digital encounter, my dear friends, we are not going to exhaust any topic. We don't want to deal with hundreds of the possible issues to be discussed. We want to open a little bit the Pandora box. You three are completely free to say whatever thing you feel like and whatever thing you are in your minds. Of course, all the attendants, and I appreciate so many attendants today, welcome to ask us whatever question regarding to the package. And basically, as we always do, we will come to 3 questions around, first of all, an introductory question, which, as it should be, deals with, let's reflect around 10 minutes on the pros and the cons of the system. Yeah. And then I would like to bring to your attention a couple of paradigms. Paradigm number 1 could be the European patent package and what I call the identity crisis. So how to combine international law, community law, national law here. What is the linkage between the European Patent Convention and the European Patent Office with this system? How is the role of the European Court of Justice here? This could be the first paradigm. And then the second paradigm, which would deal basically with the daily functioning of the Unified Patent Court. So how the different divisions are going to function, what is the role of the Court of Appeal, and so on and so forth. And then we will come to your questions. So let's come to the first question. I'm convinced that the success of the system will depend on how it is perceived by non-EU enterprises. No. So no one better than you to approach the matter from outside. We are too deep into the pot, yeah. But you can approach it from outside. So what are your views on the pros and cons? How this approach from the perspective of the United States, for instance, or from a non-member state?
Yeah, thank you for that, Manuel. It's my first day. It's a pleasure to be with you and be able to visit with you on this exceedingly exciting topic. The pros and cons from an American perspective is something, as you can imagine, is talked about quite a bit in American law firms, big and small, with clients from startups to large pharmaceutical companies. I think in my discussions with friends who have active patent practices, both in-house with companies and with law firms, that the response has been overwhelmingly positive, just from a general 30,000 feet perspective. But I should also say that there is a notable minority view that has some concerns, but the concerns are largely about the uncertainty, that they look at the structure and they see some familiarity. The Court of Appeal, for instance, in Luxembourg looks similar to the Court of Appeal of the Federal Circuit in the United States. But there's this uncertainty that accompanies this concern is similar to the uncertainty that accompanied the creation of the Federal Circuit in 1982. So that's just from sort of a general overview, where law firms and lawyers and their clients are thinking. The pros, I think, are quite significant. And if I could break them down into 2 categories, one is time, speed, and the other one is enforcement. And let me speak to sort of the speed component first. When the notion of, in terms of the time it takes to file a cause of action, the statement of claim, to resolution of 12 months or so is extraordinary from an American perspective. If you look at the courts of first instance in the United States and where cases are tried, the Eastern District of Virginia is known as the rocket docket, and they love that because you have quick resolution. And that's really important. And this is why Germany is very attractive, by the way, in the current national court system for Americans to litigate in their bifurcated model. The speed is viewed by Americans as pro-patentee, and I don't think that's a unique American perspective. And one of the reasons is that once that statement of claim is filed, the party being charged with infringement has 3 months to file their revocation counterclaim. And with limited discovery, right, discovery meaning asking for documents, interrogatories, these things that are common in American litigation, that's very limited in Europe. So in 3 months, the revocation has to be put together. That's not a lot of time. And so that notion of speed is very powerful from an enforcement perspective, from a patentee perspective, viewed through an American lens. The other thing I would say on the enforcement side, this other category, of course, the uniformity of judgment that we're so used to since 1982 in the United States is an extraordinary thing. It's not only from an economic perspective, it's cost savings, but you don't have to worry about the divergent judgments among national courts anymore. That is generally a positive thing. Having said that, though, the one concern, and maybe this is a con, is that the centralization of revocation is problematic or is a concern. That is to say, one court to revoke the patent, it has the effect throughout all the member states. That gives American companies, American firms some pause. So when from the American perspective, when the question is, do we opt in or do we opt out? This notion of centralized revocation gives some firms pause. And this is what I hear repeatedly, is that, boy, it takes one court of first instance to say this patent is invalid, it's revoked. And even though we'll have an appeal in Luxembourg to the Court of Appeal, it's not how things used to be, that we may have an affirmation of validity in France and we may have infringement in Germany. That's no longer going to be the case if we opt in. The other thing I would say in terms of a concern or a con would be, it's certainly true that the reputation of the judges that have been named is very high. And indeed, I think European judges in the patent space are outstanding, but there's that uncertainty that accompanies it. The old saying, you go with the devil you know, that American firms are comfortable litigating in Europe, again, particularly Germany. They know the system, particularly the German system. And there's this sense, if we opt in, even for issued patents, we could affect the courts. We opt into the UPC, there's some uncertainty into how patents are going to be viewed, this particular patent. And so there's just there is this sort of wait and see attitude with some firms. It's a minority view, but it's just, it is there, and it's palpable. So if I were to sum this up, I would say the opt-in pros are speed, the 12-month resolution, the 3 months for the revocation to be filed, and the limitations on discovery is a very powerful tool to opt in. The other thing I would say on enforcement is indirect infringement. The double territorial requirement now is, if you opt in, has now assumed a more generous expanse. That is to say, if an essential element is manufactured in Germany and used in France, you could still have indirect infringement. Indirect infringement for certain industries are quite powerful indeed. So I may have gone beyond my 3 minutes, but that's how I would characterize the American perspective.
Fair introduction, Claire. Very good, thank you. You see, no one disputes the need of arriving at last to a European Union patent. Yeah, we do need a European Union patent. But Thomas, is this the European Union patent we needed, and the court system we needed? What are your views? No. Thomas, you are unmuted.
Sorry, the classical error.
No problem.
Yes, certainly there have been different alternatives available for the system. As we know, you well described how long this has been in the pipeline. And I personally would have preferred a more full-scale European Union regulation with the creation of an independent EU right and specialized court. But of course, we are not there, and it seems that we are not getting there. So we are stuck to this system, which is, I agree with Greg's analysis very much. It has its uncertainties. Of course, all new systems have uncertainties in the beginning, but I would say that this system is specifically experimental in many senses, and there are, in addition to the centralization of revocation, for example, there are also systemic risks which also pertain to the role of EU law, the role of the European Court of Justice, how it might start to interpret, even quash some parts of the system. Even the whole system might be at risk we do not know much about it yet, and of course, I think the formative years, first 2 to 5 years, they will decide then how risky the system is and how popular it will become. But I think these issues they remain with the system for some years at least. You mentioned also the indirect patent infringement. I agree, it's very interesting. But if you look at the other side of the coin, if you look at the exceptions to patent rights, I think they are very poorly regulated. For example, compulsory licensing only on the basis of national law and national territories. If you look at the COVID pandemic, for example, I think there are signs that maybe they should have been regulated differently. Thanks.
Thank you, Thomas. Thanks very much. Matthias, this is going to be quite challenging. 1st of April arrives, so I said it's 3 months. No, in a couple of months, this starts. How do you see? How do you appreciate the system?
Look, I promised myself, since this is an event on looking forward, right, to not be negative, right. I said I'm going to leave all my negative thoughts about the system.
That's a good starting point.
I'm trying to be supportive.
The system will be there, so
the system will be there. We have
so
to live with it.
Let's work for it. Yeah.
Just a few remarks on what Craig and Thomas have said. I think if you talk about pros and cons, it's always a matter of perspective, right? So for who, pros and cons, right? If you think of centralized infringement, it's obviously a pro for patentees. If you think of centralized revocations, it's a pro for potential infringers and so on, right? On the side of patentees, you have another issue that is the fact that you cannot drop patents in not profitable jurisdictions anymore. Right? You'll get a patent that covers everything, and that along the term of the patent might create different problems. Compulsory license is another issue. Whether they're relegated to the national systems or whether they're possible at all, which I think is still debatable. Is another big deficit that we have in the system. So overall, I think it's a system that is built for big tech and big pharma, right? And it's also a matter of cost, right? I mean, if you think of costs, and they published the court fees and the reimbursement costs some months ago, I think. So especially in U.S. standards, it's pretty cheap, right? It's a very cheap system. You also have cost reductions for small and micro enterprises. But what about the entire middle tier sector, right? What about medium-sized businesses? They have no cost reductions, and are they still going to be able to? And it's not only a matter of cost. Are they going to be able to navigate this complex system, which at the end of the day consists of, I mean, if you look at the patent landscape in Europe, we're going to have national patents, we're going to have European patents that are subject to the UPC jurisdiction. We're going to have European patents that are not subject to UPC jurisdiction. We're going to have unitary patents. So I think this will be problematic, especially for medium-sized businesses that have to navigate all these new complexities of the system.
Very good, thank you, Craig. You are one of the professors, not very much, I should say, professors in the United States, understanding very well the European system, since many years ago, and we do appreciate this. And you could agree with me, perhaps, that Europe is as glorious as miserable. Yeah. And all in all, what we bring on board just in a couple of months is something that is glorious, because for the first time we are able to bring something that it was so needed, and at the same time is miserable. The system is so complex, and it's so difficult. This is going to be so difficult to bring it on board. But this is Europe. Take it or leave it. Yeah, I have to confess myself that I am completely in love with the European construction, because it's miserable and because it's glorious. Yeah. So, but now I'd like, Thomas, if it is possible to come to the first paradigm. Yeah. Which is what I call the identity crisis. So how to combine the application of European Union law, international law, and national laws here, and how this is going to function in your view, because this is the part of, let's say, of the complexity. Yeah.
Yes, thank you. That's indeed a great question, because I think it is a hybrid, unprecedented measure in the sense that the whole regime combines three types of legal sources: international norms, European Union norms, and national norms. I think lawyers are really creative when they design such measures. So I think there is a lot to be resolved here. So the key international measures are the European Patent Convention, the agreement on Unified Patent Court, but also other international IP law measures pertaining to patents could be applicable. And it seems that it will be some type of a monist approach with the new court, the UPC, so it might apply at least some of the international law, patent law measures directly. It is totally possible. But the key question, I think, is how far EU law and especially the European Court of Justice enters into the area of the new unitary patent. And I think, as we know, the EPUE regulations, the regulations are actually very thin. They don't contain any substantive patent law provisions. Almost all of the substantive patent law is either in the UPC agreement and in the EPC. So these cover the grant, they cover interpretation of patents, they give the exclusive rights, they give the exceptions and so forth. But these measures at the same time are outside EU law. And I think it has been the explicit or at least implicit intention of the drafters to exclude EU law and exclude the competence of the ECJ, the European Court of Justice, as far as possible from the system. But I have also tried to analyze it from the perspective of EU constitutional law, and I can see that, for example, interpretative effect relating to directives could be used by the EU court. So it could give it avenues to also to pronounce something on the AUPC agreement, which is the court agreement between the participating member states. It could even give it possibilities to pronounce on the compatibility of UPC decisions with EU directives, for example, the biotech directive. There are also other avenues for the ECJ to go to this area, and I have especially thought of fundamental rights, which of course is a topic that is also very topical in the copyright area, where the ECJ uses fundamental rights in almost all of the cases, and also rewrites the law and creates new law with fundamental rights. And I can see that this is possible also here. Although the EPUE regulations, the EU law measures are very thin, they open the door for the ECJ to evaluate also the other measures from the perspective of whether they are compatible with fundamental rights. And in the Fundamental Rights Charter of the EU, as you know, we have something like 47 different articles substantiating different rights. So there is ample material for the court to use. Another matter is then, of course, will the ECJ have the chance to do this? And this very much depends on the UPC, where the UPC wants to make preliminary reference questions to the ECJ. I would say, why would it have that motivation? Because it would just give part of its power away to the EU court. But on the other hand, it inevitably will do it at some instances. And then the question emerges, what will the ECJ do when it has the chance to try to unionize also these international law parts of the regime, because I think from the perspective of patentees, I think this unionization and the competence of the EU court to pronounce on different topics, it's a risk, and it could make eventually the whole system unpopular with the patentees. So I'm not sure whether it will go into this direction, but I think the ECJ will have avenues to do it if it so prefers, and I think in the end it will probably go in that direction. Thank you.
Thank you, Thomas. Very, very good introduction. You know, we see that there are different bodies of law, yeah, international, European, national, just flying around, but also there are a lot of other bodies invited to the party, let's say, yeah. We have Matthias, the European Patent Office, and the Court of Justice, as you have said. Yeah. How do you see the role of each one, Matthias?
I would love to contradict Thomas in order to heat up a little bit the debate.
That's great. That's the spirit. That's the spirit of the
country. I agree with most of what he said, and maybe just to give it a little bit of a different twist. So an issue that I think is also important, if we just leave aside for the moment all the nitty-gritty details of how the system operates legally, is the aspect of governance, right? So I think the aspect of sovereignty and of political autonomy, that's something that concerns me a little bit. And I think the question behind all this is, who's going to make patent policy for the internal market, right? So who's going to set the direction for the long-term development of law in jurisprudence in patent matters? And my concern is that it's not going to be the EU. It's going to be the UPC together with the EPO. And the thing about these especially about these international organizations or institutions, however you want to call them, is that over time they tend to develop a personality of their own, right? They tend to, especially if they're epistemic communities, they tend to get a normative identity of their own. And Manolo, I know you have a certain affection for the EPO, so I'm going to
yes, sir.
Smooth about this, but just think of the EPO, right? I mean, what started off as a technocratic institution that was responsible for examining patent applications and granting patents, has over the years, I think, created a certain political ambitions.
Yeah.
So just think of the entire jurisdiction on
filling the gap in a way, Matthias.
Sorry,
filling the gap in a way.
Yeah, well, filling the gap. That's the question, right? Where's the gap, right? I think if you look at these cases on computer implemented invention, essentially biological processes, we've had a couple now. There is a certain risk that at the end of the day, the EU will be stuck between the EPC and the UPC, the EPO and the UPC, right? Or, well, maybe it will not be. It will actually be sidelined next to both of them, right? It will be looking from the outside how both of these institutions shape patent law for the European Union, and I don't think that is the way to go forward. It might not be a problem for the next 10 or 5 years, right? But if you look 20, 30 years down the road, I think we have a certain problem there. And at this point in time, with the UPC, well, being operative in very short time, I think that the EU has somehow given up on the entire project, right? I have the feeling that after all these years of back and forth, they have come to accept that it's better done than perfect. And I have my fears, although there are ways for the ECJ to give its own imprint on the system, that the ECJ is not going to be so proactive in that. Although this may also be a chance, right? So the fact that all substantive patent law has been taken out of the coverage of the EU may also be a reason for the legislator to be more proactive, right? In terms of secondary union law, now they have to do something. So maybe to close on a positive note, maybe that's also a chance. for the system.
Thank you, Matthias. Thank you. I expected a much contradiction. I don't see really the contradiction. You are complementing each other. That's good.
Still have time.
That's also good. Listen, Craig, the whole process for building this unified patent court and the unified patent court agreement has been amazing. I guess that from outside Europe, it has been quite an exercise. I've never seen ever in the history of law a process where so many thousands of people have contributed, people, institutions, organizations from all sorts and fields have contributed to this. In a way, it reminds me the way things are done in the United States, yeah, before arriving to the Congress. Now, what is your experience there? What could you tell us on this?
Yeah, just first of all, Manuel, Europe has always been glorious to me. I don't see the bad side to your prior comments when I come over there. I think it's all good. No, but building on Matthias and Thomas's excellent comments, just a few things from my perspective I want to highlight, and these are more questions. One is, thinking of the American model. We fought these battles a while ago, and with the relationship of the various circuit courts, the multiple courts of appeals we have, and the lack of uniformity in the creation of the federal circuit. And now, to Matthias's point, 30 years from now, what would the UPC look like? And I think that our experience at the federal circuit level has we could learn much from the mistakes that were made there. And perhaps we'll say something about that later. The questions that are raised for me are, and I think Thomas and Matthias touched upon these in a really important way, is there's one of who's going to drive the evolution of European patent law? Who's going to be that driver? Is it going to be the UPC? Is it going to be the ECJ? How restrained, how active is the ECJ going to be? When will they intervene? Related to that is, if one of them is going to be the driver with sort of the EPO in the shadows asserting itself when fit, if those two institutions, the Court of Justice and the Unitary Patent Court, are going to be the drivers, this looks an awful lot like it has common law influences. If the judges are going to assume a role of not only law interpreter, but policy maker, you cannot escape the policy implications of these decisions. The question of comparative institutional advantage is paramount. Are the judges capable of doing this when that role has not been in the forefront in the past? What is the role for legislation compared to decisions coming from the UPC or the Court of Justice? And when will the very capable European Patent Office assert itself? So this is a very common dynamic in the United States, where you have courts, legislatures, and agencies battling it out. So that's one thing. The other thing I would say is that with all this uncertainty, there's true advantage to this, and that it is an opportunity for multiple voices to create something that is really quite terrific. And that uncertainty could give us pause because we don't know, but it's also very exciting. And particularly when you have multiple players with divergent interests that can have a say. So it's very exciting from American perspective to see how this plays out. And there are indeed lessons that can be learned from the American experience as well.
Thanks, Craig. As in the encounter, we like to say that we bring more questions than answers. Yeah. So don't worry about bringing questions, because in fact what we have here is questions and questions, and this is what really merits. As I would like to come right away to a question of our audience, because it's related to what we are discussing now. You have it as a question number one, a question from Inma Cano Lopez. Yeah, so you can look at it. I will read it for you. It says, how could the creation of a European Union patent right fit together with the UPC? Could the ratification of the UPC prohibit the future creation of a harmonized European Union patent right? Thomas, you want to jump very briefly? Yeah, and then perhaps Matthias?
Yeah, it's a great question. I think certainly it is very difficult to amend the agreement on Unified Patent Court because I think major major modifications at least would require unanimity, and even more difficult with the EPC, of course, because there are external members on board. So then probably this means that there will be some impediments, at least for some type of, let's say, bigger renewal of European Union patent law. So probably we are more stuck to the system than probably not that many thought of originally. Certainly there are also possibilities within the agreement on Unified Patent Court to make certain modifications so it can be modified also afterwards. So something is possible there, and certainly also the European Union can, for example, give new directives in some areas, like it has done in the biotech area, and try to do in the computer implemented invention area. But I think, yeah, it will be more limited, and I think the political pressure is not there anymore. So very likely that the system will develop more on the basis of the new unitary patent system.
Thanks, Thomas. Matthias, perhaps just a minute.
Yeah, just quickly. I'm also afraid that's going to be the case, because I mean the problem is, if you really want to end up with a truly EU patent, then you would need an EU institution. You have to take the EPO out of the equation, right? Because you need an EU institution that grants that patents on the basis of union law. And as long as that's not the case, I think we're stuck with the system we have, and I think it's very difficult to get now from where we're standing to get to a truly EU patent.
Yeah, thank you, Matthias. Craig?
Yeah, I don't have much to add to that, other than the politics of, there's always going to be this notion of political influence, and I think that we need to let this play out a bit before we sort of address these types of next steps, and let the dust settle a bit and see how the courts and the package play out over the next year or two.
Mm-hmm. Thank you.
Just a very quick comment on political influence, if I may.
Yes.
And I think there, because you mentioned that we'll see how the judges develop the system, right? I think we have the problem of democratic legitimacy at the end of the day, especially in relation to the EPO, right? Because at some point we have to make sure that what these institutions do is also what society wants. And there is a gap there in terms of democratic legitimacy. At least it's much more difficult to make the system legit if we're talking about the EPC and the UPC dealing with or developing patent law for the future, right? See, that is problematic, I think.
Thank you, Matthias. Take into account that this is the first encounter dealing with this topic, so we are not going to exhaust any matter. I have the feeling that now Craig and Thomas wanted to jump again, but let me moderate and try to move to the second paradigm, because there we have another question expressed by Fernando Martinez Tejedor that fits very well with this. Yeah. So the second paradigm would be the daily functioning of the Unified Patent Court, and there I would like you, Matthias, perhaps to introduce very briefly, because we are running fine in time, but we have around 15-20 minutes more, not more. Then how cooperation between divisions, this very complex system, central, local divisions, the local divisions themselves, how is this going to function in your view, and what is the role of the Court of Appeal there? And this I would like to relate it directly to the question of Fernando Martinez Tejedor. He says, will predictability of case law improved after next summer entry into force onwards, and how?
Yeah, thanks for that. I think in terms of the daily operation of the court, there are different. Maybe I'll just address selected aspects of it, right? Because it's impossible to be exhaustive. But I think one of the issues that we have there is all this dynamics between the central divisions and the local and regional divisions, right? Because if you think of the system, the bulk of the infringement litigation is going to happen at local and regional divisions. So the central division is only going to be involved in infringement when it's a declaration of non-infringement and when there's a counterclaim of revocation and both parties agree to refer the entire case to the central division. So these are going to be the only instances where the central divisions actually deal with infringement issues. And that I think that raises a question, because the main clients of these central divisions are going to be the potential infringers, while the main clients of local and regional divisions are going to be patentees. And I think that inevitably raises the questions of how patentee and infringer friendly the divisions are going to be. And the follow-up question, obviously, there is one of cooperation between the divisions. So how willing are the local divisions, for example, going to be to bifurcate proceedings and to refer validity questions to the central division? And from what I've heard from the judges that I've talked to, I think they're all pretty willing to not bifurcate. I think many of them are gonna deal with the entire case. They're gonna do infringement and validity. Also the German judges, by the way, right? So I think there's some interesting dynamics that will happen there, and we'll see how it plays out.
Thank you.
And the second question is we have on the daily operation is something that has already popped up in Thomas and also in Craig's interventions, is the system of preliminary references, right? So to what extent are these divisions going to make use of preliminary references to the court? What type of questions are they going to ask? And then the question from the other side is, to what extent is the Court of Justice willing to rephrase these questions to somehow in order to answer the questions that he likes to answer instead of answering the questions that the parties ask, right? So that's also something that the Court of Justice is very, very creative at, right? And there you have another problem, because I think that the divisions will not be very happy to make references because it's costly, because it takes time, and all of these are things that are not very that parties will not be very happy about, right? So I think there might be something at least to have a look at on how this develops. And then maybe a third aspect to conclude is and there's where also the Court of Appeals plays a major role, I think, is the issue, and since we have a US American here, I think we have experience, is the issue of injunctions, right? And we have in the context of the UPC, we have a May system, so the court may or may not grant an injunction. And since with the Brexit, we lost the last common law country which is used to dealing with these questions as to their tradition. I wonder how comfortable the judges are going to be in. I mean, they're all excellent judges, right? And no doubt about that. But I wonder how comfortable they're really going to be in dealing with equity considerations or proportionality considerations within the context of injunctive relief. And that's one of the areas, I think, where, especially because neither the UPC agreement nor the rules of procedure give any guidance on how to balance interests in the context of an injunction. Not even whether the public interest plays a role at all in these cases, which it does, for example, in the US, right? So I think there's going to be an important role of the Court of Appeals to create some harmony in the system with regard to injunctions, which is at the end of the day the most important means that the patentee has at his disposal, her disposal.
No doubt, Matthias. And Gott sei Dank, the president of the Court of Appeal is a very reliable judge. These are good news also. Thomas.
Yeah, thanks.
Try to be brief, because there are two questions on the spot waiting for us that are really interesting.
Sure. Yes. I agree with what Matthias said, and I also think that the role of Court of Appeal might also become quite decisive. So the rules and AUPC and the rules of the court, they require that the rules should be interpreted consistently and coherently. But how to achieve that in practice, I think that will be the real challenge. It might be that some of the courts are more favorable to the patentees and some some not, and how to avoid such situations. It will be a challenge for the whole system. It might also be that the Court of Appeal, maybe especially possibly also other courts, will start to create new patent doctrines and related doctrines out of thin air. It's totally possible that they could start to act like common law judges in the absence of a background legal system, proper background legal system. So just combining from different legal systems and trying to develop these new doctrines. I would say that it's more likely than sending many questions to the ECJ for preliminary rulings. So they would rather keep that power to themselves. Thanks.
Thank you. Craig, you want to add something?
Yes, very briefly. These are great comments. It's interesting, Matthias said that built into the architecture of the courts of first instance is forum shopping. And I think that's absolutely right. And of course, it was forum shopping in the United States in the 1970s that gave rise to the Court of Appeals for the Federal Circuit. That forum shopping can be a positive in the sense that it leads to experimentation, it leads to divergency. It's like a laboratory, various laboratories. And the Court of Appeal in Luxembourg can impose uniformity and choose among what they think is best. What concerns me about the structure of one court of appeal is something that we've encountered in the United States, is that we were so driven by the desire for uniformity that we created one court. From 13, we went to 1. I don't know what the optimal number. I would love to have seen 2 courts of appeals in this particular European structure that could learn from each other, that could work within the various cases from the courts of first instance. That here we got an appeal from the Central Division in the biotech area. This makes certain sense. And another court of appeal could hear an appeal from another court of first instance. And over time, this percolation would lead to a type of consensus. And then maybe the ECJ intervenes like the American Supreme Court. But I think it's important that not to get blinded by the power of uniformity and allow for some experimentation. And I think that experimentation will take place among the courts of first instance. And I'm curious to see what the Court of Appeal, their standard of appellate review will be. How deferential are they going to be in terms of national mores and norms and laws, or how authoritative are they going to be? So I think it's important to balance uniformity and experimentation, and that's a real challenge. But you could handle that more structurally than otherwise. Much more to be said, but I will pause there.
Thank you, Craig. Listen, we have quite an amount of questions, but there are 2 I would like to deal with briefly, because both are elephants in the room, let's say. Let's go to the first one, brought by Ivan Prancev. What I understand when reading the question is that both English lawyers, English institutions, English organizations, professional organizations, and English patent attorneys have made through years a terrific effort to enhance the UPC, the rules, first the agreement, then the rules, especially the rules. Yeah. So in a way, what he says is, to what extent were procedural rules before the UPC shaped by English lawyers, and a great extent, yeah, and to what extent do they emulate English law patent litigation? And this is true. This is an elephant in the room. Now the UK is not there, and the continental countries of the European Union, 17 of them, are going to apply something that was supposed to apply for someone else. Could then the absence of English judges and counsel be felt once these procedural rules become live? Yeah. And so could their absence even scare users off at the beginning? This is a very, very fair question. Elephant in the room. Very briefly, 1 minute each.
Well, I think it gets to the question of the influence of a common law approach to interpreting the patent doctrine and cases that come up to the Court of Appeal. To what extent are judges going to be more proactive and feel free without the guardrails, right? There are fewer guardrails in the common law than are in the civil law. I think this notion of how judges evolve and move the law is a real one.
Good. Thomas, perhaps?
Yeah, I think it's somewhat ironic that English legal system quite a lot determined the rules, and also I think the absence of EU law and the absence of the competence of the ECJ is much because of our English colleagues. So this is a bit ironic from that perspective. I think probably then the judges will also have a look at English case law, but of course they are not bound by it to any extent. So it will be another interesting experiment to which direction the interpretation of the rules will develop with some old English doctrines and case law in the background, but not binding, and no English judges in the room to help in the interpretation. So it will be interesting to see.
Yeah, thanks. Matthias.
So very quickly, I think the absence of English judges in the UPC is not a problem per se. I think the ones we have are more than capable of making up for that. But what I think will be interesting is how strategically companies are going to use the UK system, and see how they can litigate there in comparison to litigating within the UPC system. I think there's going to be an interesting dynamic that will develop strategically.
Thanks, very good. There is a question from Erika Gironi we will not have time, I'm very sorry, to deal with, and I apologize for this. We will write down, if you want, if it is possible and you feel like the answer in written. But there is a second elephant in the room that I didn't want at any rate to bring on the table today. But this is a question. So it's Álvaro Velázquez. So the question is, recently, the former Spanish Minister of Industry, recently means very recently, and former means because she was released, let's say, from her responsibilities yesterday, because she's going to participate in elections. So now we have a new Minister of Justice, yeah? Recently, the former Spanish Minister of Industry announced that there might be chances of reconsideration of the Spanish position vis-à-vis the UPC during Spain's presidency of the European Council later this year. Is that a real possibility, or could Spain remain outside for the time being? What are your very, very brief feelings about that? And behind this, perhaps if you could move further than Spain, the question is, could the system afford to work with 17 and not with 27? Do you think we should make such a huge effort to get the enhanced cooperation one day being removed, and because all of member states of the European Union are members of the system? Do you want to start, Matthias?
I can start.
Because
I think
it's serious because you are Spanish.
And I think it's a possibility, and I think it's expected, right? I think at the end of the day, all of them will have joined at some point. The question whether you can then remove enhanced cooperation is, I think, a much more complex one, right? I think you cannot just say, well, now I'm going to remove enhanced cooperation and I'm going to start a new EU system, right? That doesn't work, right? Now we're in enhanced cooperation, and we have the result of enhanced cooperation, which is this UPC, which works together with the EPO, and we have the EU or the ECJ on the sidelines. So that's going to be much more complicated. I mean, formally you can get rid of enhanced cooperations. In terms of substance, we'll have to live with that. But in any case, I think they will, more and more member states, even the most reluctant ones, will join, and it's just politics, right?
Thanks, Matthias. Perhaps Craig and
yeah, I can't speak directly to the Spanish position, but I will say I like the fact initially that there will be jurisdictions outside of the package, because and Matthias alluded to this, strategically it may make sense to litigate in a particular jurisdiction outside of the outside of the UPC. whether you file in the UK or you file in Spain, sometimes it makes sense just to file a Spanish patent or an English patent and take that through for strategic reasons. And this is where good counsel comes. So from a structural perspective, not a political perspective, I like the fact that there are these outliers that may or may not join, but for the time being, I like it.
Yeah, thank you, Craig. Thomas?
Yeah, I think from the whole system perspective, it would be great to have Spain on board and also the others. So of course, it makes much more economic sense to apply for the new patent if the area is bigger and economically more viable. But on the other hand, also, I think the EU member states which are outside, they can also get many of the benefits of the system, although they are outside now. And of course, for example, the division of the courts is over, maybe, so there are no similar political benefits that were available in the first place. So there are pros and cons.
Yeah, thank you, Thomas. Of course, this is an issue that for Spaniards is very sensitive, as you can imagine. So I will not pronounce myself, but just suggesting as a possible, let's say, not way out, but movement, that perhaps at a certain point it could be possible to think of the possibility of splitting the two issues. So one thing is the unitary patent, or the European patent with unitary effect. In fact, this is the nomenclature, where the issue of the translations is a very key issue. Another thing is the UPC. The UPC deals not only with unitary patents, but also with classic European patents. I don't know, but perhaps trying to answer in Alvaro, perhaps there could be an avenue trying to explore whether the political side could be put aside and explore the possibility of moving further into the possibility of approaching to the UPC just for the classic European patents. Yeah, there are more questions. We cannot deal with them. I'm very sorry. It will be amazing when you will watch the video again, Matthias, Thomas, and Claire, how many questions have come into the table. Yeah, how many questions, and I do appreciate it very well. I'd like to give you just a couple minutes, to each one, starting with Matthias, perhaps, for concluding. Yeah, if you want to make a last remark.
Yeah, I can make a last remark. I think if these 60 years have told us something, these 60 years of back and forth, it's to probably to hope for the best and expect the worst, right? So that's what I'm going to do, and we'll see how this this beast evolves further.
Yeah, thank you, Matthias. Thank you, Craig.
I think, just to reiterate, I think it's such an exceedingly exciting time now in Europe to be a student and practitioner and scholar of patent law. From a greater remove across the pond, I look forward to see how this evolves with the lessons, things we did well and wrong in the United States.
Thanks, Craig. Great. And Thomas?
Yes, I think Manuel described it nicely, that this has been a frustration for the EU, that it has taken so long, but it has also been a personal frustration for me. I already wrote my master thesis in 1995 about the Community Patent Convention. I thought that it will come into force in a couple of months. Then I made the same mistake again in 2015 or something like that. So I'm really happy that it's now really coming into force, and also thrilled to see how it develops. So it will be a real legal experiment, and yeah, hopefully a successful one.
Thanks, Thomas. Before giving the floor to my dear friend and co-director, Professor Laurent Manderieux, let me conclude by bringing on the table that it's only a couple of months until the entry into force of the system and the application of the two regulations, and we need to enhance a lot of discussions like this one in a calm way, and not excited, yeah, and basically going further into details. Yeah, this has been a broad discussion. This is an open the Pandora box, let's say. I appreciate very much that you kept the time, and I appreciate very much that you bombarded us with so many questions and even some answers. And please now, Matthias, Thomas, welcome to the family. Craig,
thank you so much.
again in the family. Laurent, you have the floor.
Thank you very much. Thank you very much to our distinguished presenters today and to our moderator. I think that we are constructing together also the way the stakeholders, the way the opinion will react before a new creature that was awaited for so long. And this is therefore a very important moment for our digital encounters. I think we are also helping in constructing and shaping the future of the European patent system. This encounter will be watched and rewatched by stakeholders, policymakers, academics, students, professionals, precisely because of its wealth. Our next global digital encounter will be dedicated to copyright and design, a relationship which is also very complex, which also brings many questions between the EU world and the world of other countries, the legal constructions of other parts of the world. The equilibrium established will remain as it is. Will it be changed? What will be the role of WIPO in it? These are all the questions that in a month's time, the Global Digital Encounters will reflect upon together with all of you. In the meantime, food for thought with this wealth of knowledge and of points of view expressed today. And I wish all of you a very nice evening, a very nice afternoon, a very nice morning, depending on where you are in the world. We know that many people will watch this encounter from all over. There will be a report that will be produced on it, a report that our PhD team is preparing as of now, so that also what has been said today remains not only codified in a video, but also codified in a text and in a publication. Thanks to all of you for your attention. We are happy and proud that with this present encounter, we are about to have 3 years of existence as Global Digital Encounters, and our applause goes to our speakers and to our public. Thank you.
Thank you.